Could I now go to just pick up a matter from the one of the earlier sessions, and that relates to the rank or position or whatever it is of head of state. And Ken Handley knows what has been happening in relation to the latest intellectual exercises in clarifying that issue.
This is a happy story. David Flint and I, some years ago, asked Sir David Smith to write an article for publication in a law journal on the topic, "The Governor-General is our head of state." We gave him certain guidance on the way in which such an article should be framed in order to merit publication in a peer-reviewed journal. And it was offered to the Federal Law Review, which is the publication in the ANU, and the Australian National University in Canberra. They rejected it. They were asked to reconsider it. They rejected it again. So what do? We went from a journal which has a circulation of 500 to the Australian Law Journal, which has a circulation of 12,000. They published it. It was published last December in the December Australian Law Journal part. It was adopted by the then editor in the January issue, and then since then there's been silence from the Republican camp. The ALJ is a bit behind schedule. We've only got the July issue so far, but Sir David Smith makes a convincing case based on parliamentary practice, public service practice in Canberra, diplomatic practice from Australia, the decision of the High Court in 1909 in the case involving the Senator for South Australia, where the High Court said the Governor-General is the head of the state of the Commonwealth, and the Governor of the state is the head of the state of the state. And he also picked up statements in the Privy Council in a Canadian case where the Canadian Constitution was contrasted with the Australian Constitution, and in the engineers case when it went to the Privy Council, to indicate that the Queen had given up all executive authority in Australia to the Governor-General, who wasn't the Queen's delegate. Queen's representative, yes, but he exercised on his own authority all the powers in the Constitution. Finally, there was an Act of the Federal Parliament in 1976 dealing with diplomatic representations and protection of diplomatic and government persons, which declares the Governor-General as the head of state of Australia and entitled to international protection as such. So Parliament, the courts and diplomatic practice, political practice, all point in the one direction: the Governor-General is the head of state. Guess who appoints and dismisses prime ministers, exercises all the executive powers in his own right or her own right? It's the Governor-General. So David Flint and I await the response, the counter-attack from the Republicans. 7 months later, it hasn't come. Governor-General is our head of state. Game, set and match.
Thank you, Ken. That was a great achievement, and you drove it. You really drove it, reminding me that I should be looking at a draft and doing some study and advice on it. It was a very good project, and thanks to you it was undertaken. Thanks to you it appeared in the Australian Law Journal, which is not only has a large circulation, it is the oldest and most preeminent law journal, I think, in Australia. Now, Will, would you take the microphone, and Will choose. I delegate to Will the choice of questioners, otherwise we'll get contradictions, and we'll invite questions from the floor for specific members from the panel.
Could I make a small point?
Yes, certainly, and Ken is making a point.
One of the most bizarre things about the final abolition of the Privy Council appeal by the Australia Act was that the Keating government adopted the optional protocol to the International Convention on Human Rights, which gave a right of appeal from Australia to the Geneva Convention, to Geneva Committee on International Human Rights. Bizarre.
Good point. Yes.
I sort of pick up on that, but I want to respond to, well, not respond, but comment on what John Stone said about when he was the only person who put up his hand to say he regretted the abolition of appeals to the Privy Council. I think you make a good point there, and I can see why you're right, that it probably would have been better for Australia had we retained appeals to the Privy Council. And you say, well, maybe that makes you reactionary. And one thing I'd like to point out about this, I think, is I see what you're saying, and I think I'd agree with you. I don't know if I would have voted that way when he asked you, but I accept your argument. But the important thing is there was a time earlier on, I can remember, there was some brief discussion that there might be a sort of Supreme Court of the Commonwealth of Nations. That there was a time, I think Sir Berridale Keith may have commented on this idea, and it didn't get anywhere. But the point about that is that would have been to somehow revise or reform the Privy Council so that it somehow became reflective of the modern Commonwealth of Nations. And the point I just want to say about this, would it make you a reactionary or a conservative? I think it would have been good, in retrospect, if Conservatives had have thought about that more and had have seen that if the Privy Council had been revised or modernised in some way to make it reflect the current situation of the Commonwealth, it may well have been easier to make the argument to say, well, this is now something that we should keep. Because Conservatives didn't do that, it then fell to Labor to abolish the whole thing, whereas I can see the point of why it would have been good to do that, but I think it would have required Conservatives to do something like establish a convention, let's say, that all retired Chief Justices from around the Commonwealth automatically became members of the Judicial Committee of the Privy Council. I know they were sworn of the Council, and so they could do that, but there could have been a reform that somehow established that as a convention, and that kind of thing may have made it such that in 1986 Conservatives could say, no, actually, this is a good thing, it's relevant, we can keep it the way it is, and there's a benefit in doing so. And I think the failure to do that, in retrospect, and I know that much earlier on they had thought about this, the failure to do that left it open to Labor to say, let's just get rid of the whole thing. And I think that's where there is, I think, a difference between being a reactionary and a Conservative, that it was open to Conservatives to say, we should preserve this through some kind of reform, and the failure to do that allowed Labor to do what it did and makes it now look like a reactionary position.
Before I hand that to John Stone to comment, my recollection is that the original draft constitution, as approved by the Australian people in the referendum, did not contain any provision for the Privy Council. It only contained provision for the High Court. It was Joseph Chamberlain, yes, the Secretary of State for Colonies, who insisted on the change. He was reprimanded for doing that. The premiers withdrew. They pretended they were very upset. He said, I want this, and he wanted something else about shipping. I've forgotten what it was. The premiers all said, oh, we'll have to go back to Australia. It's terrible. It's shocking. They went into another room and they joined hands and danced around because they were so delighted that they got it through. But Chamberlain was criticised strongly in the House of Lords and House of Commons for interfering with a constitution which had been established. John, did you want to comment?
I don't think I need to comment very much apart from what Damien has said, because essentially I think he's really making some of the points that I might have made myself had I thought of them. But on your point about Chamberlain's intervention, that's quite true. His intervention occurred in London itself when the Premiers had gone off to speak to the Colonial Office and to, in effect, get the stamp of approval on the Constitution proposal. Chamberlain's concern, I think, had to do with the Navigation Acts, yes, protecting British shipping and so on. But and in the end, it was accepted, as you say, ostensibly reluctantly, but actually without much real disapproval. No, I don't think I want to. There were these rather, I think, arcane ideas floating around. I actually think that the principal reasons, there were in my opinion, two principal reasons why that provision was made in 1986 with the Hawke government. One was what I might call just straightforward xenophobia, the kind of thing we saw from Peter Fitzsimons this morning, hate the British. How on earth can we have the British, lording over us, etc., which is nonsense, of course. And the second was, I think, probably a political calculation on the part of people like Gareth Evans, who I think may have been was he still then the Attorney General? I'm not certain of my facts there, but I think
maybe in Foreign Affairs.
Maybe in Foreign Affairs by that time. Anyway, he would have been one of the movers and shakers within the cabinet on the subject, even if he wasn't any longer Attorney General, who I think would have made a calculation was much better not to have the High Court subject to judicial review, because on the whole, High Court has favoured the Labor Party all along.
Ken, did you appear in the Privy Council?
Yes, between 67 and 86. First of all, before the Great War, the Privy Council was moving to a Commonwealth Court. Sir Samuel Griffiths sat over there, Joshua Williams from New Zealand, de Villiers from South Africa, and their Indian judges for Indian appeals. The Great War put an end to that, and it was never revived after the peace. Point one. Point two, Privy Council was abolished 3 times. 68, federal law. That was a Liberal Party initiative, driven by Sir Garfield Barwick. Then 75, Whitlam abolished appeals from the High Court in state law. There was still an appeal from state court to the Privy Council. That went in 86.
Yes, I remember. I agree with you entirely. It went in stages, and it's interesting that the first stage was actually a Liberal government that removed appeals from the federal appeals. The federal appeals were stopped in
federal law.
Yes. Good. Any further questions? Yes.
Question to Margaret Cunneen. Can everybody hear me? Or? Yeah. And that's in relation to the Murray Keir prosecution. I think that there was a letter from Lloyd Babb to the Parliamentary Committee on ICAC, in which he said that the DPP commenced a prosecution in October that went for about 3 weeks. Defence then subpoenaed records from the ICAC, and they found that something like 27 statements, many of which were exculpatory, hadn't been provided to the DPP. As a Crown prosecutor, if the police withheld exculpatory material from the DPP, what would be the effect of that?
Well, the prosecution would fail. That would be the first effect.
Margaret, could you explain what exculpatory material is?
Oh, yes. Well,
I don't.
Evidence which tends toward innocence, in effect, the evidence which doesn't tend towards the proof that the accused person has done what is alleged against him or her. In fact, I don't know whether the present Commissioner of ICAC even believes in it, because she said this to the Parliamentary Committee, and I think I quote her accurately. The ICAC doesn't deliberately withhold so-called exculpatory evidence. So-called. Now, first of all, doesn't deliberately withhold. Well, if the police withhold it, if they don't examine their consciences and their briefs and sign that they have given everything over, they could be liable to prosecution individually. But the idea of so-called exculpatory evidence, I don't think that she believes that once the preconceived idea that ICAC has it as its end point, like something out of what the Packer employees are facing in China now, we can't be snide about that, because we've got our own institutions that also deny you legal advice, deny you any knowledge of what evidence is against you, and have a preconceived notion about how it's all going to end up. So-called exculpatory evidence. But I digress. Witch hunt. That was a success. Anyway, the DPP was forced to certify that the reason the costs order was made against it in the unsuccessful Murray Keir prosecution, which incidentally Mr. Keir proved his innocence because the legislation is a reverse onus. That's another extraordinary thing. He proved he was innocent, and the costs order was made there's a standard form. Is the reason this costs order was made substantially the fault of the police? And the solicitor who wrote it said yes, ICAC in lieu of police. Now, why is there is no one to be called to account for this wrongdoing? Are they so excited about having a validation bill which purports to make legal every overreach and every illegality which they have committed? Is no one to be held account for withholding that exculpatory evidence against that man? They wanted to send that man down the river. They wanted to send him to jail and destroy his life. And withheld 28 statements. Now, and the Commissioner lied about that if we accept that the DPP was telling the truth when he said that those statements were not supplied to us during the preparation for the hearing. They were subpoenaed by the defence, by Mr Keir's team, during the course of the proceedings in the local court. So does she have to be accountable for her lie to the Parliamentary Committee? Is there the rest of us would be in jail for a lot less. It reminds me of what Justice Dyson Hayden said when he was in the Kirk case in 2010, talking about specialist courts, and he said words to this effect. I was just trying to write them down, but specialist courts tend to lose touch with the standards of the proper standards of the judiciary. They tend to become over-enthusiastic about vindicating the purposes for which they were set up. They tend to exalt that purpose above all other considerations and pursue it in too absolute a way. And the most extreme example is this. And of course, can we have any confidence at all in any of the findings that ICAC has ever made, knowing that they now feel completely justified in withholding exculpatory evidence? And I say again that there are many known victims of ICAC, but there are many unknown victims of ICAC, and I feel very sorry for both. And it's just hideous. I feel that the reason that it happened to me was that I could do something about it, and I'm glad it did. But it is a corrupt organisation. It's noble, perhaps no classic noble cause corruption. It can do no wrong because it's got a crusading zeal. It's got a moral superiority and a moral infallibility. Look at when the High Court came down. The High Court's wrong. The High Court's they had to be they dragged themselves to the High Court only to be told that they haven't been reading their legislation since it started. They haven't understood their legislation since it started. The High Court was wrong. The magistrate in Mr Keir was wrong. The DPP was wrong. The inspector, the disrespect that the inspector, Justice Levine, or Mr Levine, David Levine, has been shown. So this is a mob which is completely resistant to accountability, and for a long time didn't refuse to answer at any parliamentary committee. So independence can go too far. Well, I think ICAC's about as independent as Stalin, but it's not a great. The only thing that we should have an independent judiciary, but we have to have a very, very accountable and an ICAC, which we need a strong ICAC. Well, we needed a strong police force too, even more. But we didn't really get one until we weeded out all these corrupt practices and subjected the police to scrutiny at every level, but most particularly by the judicial process, so that every policeman who makes any decision or charges anyone, every day in the courts, all of those decisions are subject to judicial review. And so back to the original point.
Margaret, is one of the answers, apart from strengthening the separation of powers, one of the answers going back to an old institution of the English legal system which has been abandoned, but which thrives in the United States, that is the grand jury. These matters are referred to a grand jury of ordinary people. The grand jury meets in strict privacy. It's in camera. It has all the powers to compel the production of documents and the hearing of evidence. All it comes up with a recommendation that there be a prosecution or no prosecution. Would that be a better solution or institution?
Most criminal accusations or quasi-criminal accusations aren't that hard to understand. But that's not to say that we don't often have very, very brilliant, intelligent people on juries, or at least some of the 12 are are educated and so on. So that's a very, very good idea. It's interesting to note how ICAC continues to say it all must be in public. And well, not only does that make the process the punishment, and your reputation is trashed ab initio. In fact, when I was talking to Mr. Warner from Western Australia over afternoon tea, the first thing he said to me, "Oh, Margaret," he said, "I thought you were a baddie." And then he did go on to say that being an SC, well, he thought, what does that mean exactly? Shit council? I take your point, but the reason that they insist on the public thing is in recognition of that they know that you'll be broken by the public process, and the danger about insisting on the public show trial is that there's such a tendency then to pick off people who are known a bit or a lot in the community. That if just someone fairly unknown is doing all kinds of systemic corruption, well, they're not going to worry about him or her, the man in charge of the contracts at the Public Works Department or something, whoever it is, because no one knows him, and the chosen media outlet, the Pravda to the Moscow show trials of ICAC, will not write anything about it because no one's heard of that person, and they can't. It's no fun to trash that person's character. This is a scalp hunting exercise to continue to champion how successful they are.
No, thank you. Now, Bruce Kirkman.
Thank you, Mr.
No one took account of the trauma of your sons, your two other sons, and your husband. And I know your mother was traumatised because
my whole family was traumatised.
How much pain she was in. Your poor mum.
Yes, but people don't realise that because you go through. I'm just completing 40 years in the service of this state. My whole adult life. I studied law at night, as many people from my background did. But I'd never been in trouble before, and I have 3 sons and who knockabouts and larrikins. And yeah, that's right. And it was so humiliating for me to be in trouble with my children and with my family. And it's 27 months ago since this started. 2 years ago today, ICAC told the press where my address, and they were all across the front of my house. This 2 years ago today, when they announced a public hearing without telling me. There are many ways why I know that they couldn't have known my address, because of the security that one has to have when one prosecutes the Brothers for Life and all the people I have done. And so my security is shot. It was obvious that ICAC never imagined that I would have my job back, and hoped that I never would, before they'd ever tested a single piece of evidence and before they ever knew. That poor girl was 000, had been blood tested at the hospital on the night, and there was no course of justice to pervert. But that was an inconvenient truth for them, and they didn't even bother to look at that. As the Commissioner said, they didn't even ask anyone who was at the accident. I wasn't, until the girl had already gone to the hospital. I hadn't spoken to her or seen her or sent her any messages. But they didn't investigate any of the eyewitnesses. So that's not a proper investigation. Investigation is a skill, and it can't be done. It's not ideally done by lawyers or by people who get in, because investigators then start to get the suspicion that goes along with investigation, and that's the beauty of our criminal system, where investigating is done by the police, prosecuting is done by a completely fresh set of eyes in the DPP, not invested in the outcome of the situation.
Thank you, Margaret. That's very interesting. Now, Bruce Kirkpatrick is going to ask a question on the electoral matters and the Constitution. Bruce.
It's because this meeting is discussing constitutional matters that it seems to me to be appropriate to ask, why is it that Whitlam and Hawke and his team reorganised the Australian Electoral Office from being the Commonwealth Electoral Office, reporting to a minister, to an organisation that reports to the Joint Standing Committee on Electoral Matters, that in fact reports to nobody except the chairman, who is appointed by the federal court through the Attorney General. And for recent weeks, some of you may have read about there being 18,000 false votes that were not followed up, which is the tip of the iceberg, because the Electoral Commission has confessed to us that the New South Wales roll has more names on it than the federal roll for New South Wales, by something approaching 250,000 names. There are 134,000 who are names that don't exist, and there are over 120,000 of names and addresses that are in twice on the New South Wales roll, and the Commonwealth pays at an election, or the state, a bit over $2.60 per vote. That's a Senate vote or a Legislative Council vote, and a rep's vote or a parliamentary electoral vote. And that amounts to a fighting fund for the party for whom those votes appear. I believe our Constitution should be amended to remove this opportunity for burying complaints. When Hawke set this up, and it was really written by Robert Ray, Graham Richardson, Mick Young, Wayne Swan and Kim Beazley, and they enacted it in 1984, and since then, in every election, we've been able to prove the numerous cases of fraud that take place, and when we complain to the Joint Standing Committee, they stuff us off. And that's been going on now for 30 years. I would like to see the Constitution changed to change the Electoral Commission to being once more the Commonwealth Electoral Office, where to be identified you have to take either your birth certificate or driver's license or your certificate of citizenry when you're a migrant, so that you appear in person and you don't have a form that you get from the electoral office which you fill out and send in to the electoral division or returning office, and they send you back a postcard saying you're on the roll unless you object.
Well, that's a very interesting question. That is whether there should be constitutional provision for fair elections and take away fraud from elections. Any members of the panel? Ken, did you wish to comment?
The great squandered opportunity of the Howard government when it got control of the Senate was, despite earnest representations to the contrary, he didn't do anything to clean up the Electoral Act. And heaven knows when the opportunity will come again. It doesn't need an amendment to the Constitution, Bruce, but it does need an amendment to the Act.
Could I ask a question on that, Ken? The 2010 election, two delinquent voters looked after by GetUp went to the High Court. One hadn't bothered to register for the election. One hadn't bothered to tell the Electoral Commission of a change of address. They claimed that John Howard's legislation, which had passed, which was law, that the rolls close on the day the elections called was invalid. They rushed that case into the High Court, and the purpose of that legislation was to stop the virtual tsunami of registrations which come at the last minute, which the Electoral Commission can't possibly check, and there's an enormous number coming in. That stopped that. When the High Court gave its surprise urgent decision, without revealing its reasons for about 4 months, and revealing it the way it voted, GetUp then skited that they had got 100,000 extra people onto the roll, because as you know, that was a very close election, very close indeed. Do you think there's some sort, if that is a problem, having the High Court decide that the Constitution says you can't close off the rolls? I found it very difficult to understand how you could justify that. Is there some solution when the High Court does that?
The High Court relied upon the provision in the Constitution which said that the House of Representatives must be elected by the people. In 1901, women only had the vote in South Australia, and infants don't vote anyway. So the people has a special meaning in that Constitution in 1901, but nevertheless, people in jail for criminal offences, carrying a penalty of more than so many years, are not allowed to vote by the Act. The High Court struck that down because a government that wasn't elected by the prisoners was not elected by the people. And they also struck down the provisions closing the roll when the election was announced on the basis that the people didn't get a right to vote. But that provision had been in the Act for a long, long time, and many parliaments had been elected by a restricted franchise because of changes on the margin, but they were still treated as elected by the people. The High Court is right in that GetUp case. The first Parliament wasn't properly elected because the women didn't have a vote, except in South Australia. So there's a real tension in the heart of these decisions, and in the developer political contributions case, the High Court gave some indication of stepping back from the GetUp case. Watch this space.
Good. And John Martinkovits wishes to add something. Thank you, Ken.
Just a quick point on the squandered opportunity front. My recollection, correct me if I'm wrong, I'm sure that others would know better, didn't John Howard deny that there was, in fact, any degree of fraud or significant degree of fraud? So that's probably why he wouldn't have acted on it.
96 election, he told Charles, I don't think there was much fraud there. If you remember 96, he got in with
The fraud will not aid, but the fraud will stop a narrow vote. 4,000 votes in several key marginal seats changed the election in 2007. 4,000 votes.
And there was one electorate in the last election, I think, which had about 30-something. There was 30-something's difference. Now, we don't know where. The Electoral Commission hasn't revealed where the 18,000 cases of multiple voting, but I think 2 of them 11 times. I don't know how you could vote 11 times and not be doing it deliberately.
Can I just add, I was working with Nick Minchin on this need for change. He had told me at the Constitutional Convention that all we had to do was make sure that people were properly enrolled. And I said, no, Nick, it's worse than that. I'll see you in Canberra. And I went to Canberra and I said, even Liberal Party people cheat. He said, really?
No.
I said, yes, mothers and daughters vote for each other. Oh, they wouldn't do that, he said. David Warren, his chief of staff, said, I'm sorry, Minister, but that's what my mother and daughter do. So he was convinced then that we should do something about it. He spoke to all his cabinet colleagues and got them to agree to vote to change the system. But John Howard said, no, we'll only do it for provisional voting, because if we get provisional voting through when we win the election in 2007, we'll bring it in generally after that. Nick asked him afterwards, why didn't you approve it? You had that extra number in the Senate. He said, I lost the western suburbs of Sydney. So I said to Nick, doesn't he know he's lost that already? And I wrote to John twice. I said, if you don't bring it in, John, you'll not only lose the election, you'll lose your seat as well. And I know that because Keating had said 3 months before the election that they were going to take Bennelong. And that's what happened.
Thank you. Any further questions?
Can I just make the point that in Fiji, you vote by putting your thumb on an indelible ink pad, so you can only vote once unless you cut your thumb off.
Lloyd.
Mr. Chairman, this is a general question to the panel.
A little closer, Lloyd.
A general question to the panel. When I was at the law school, I was taught that the apartheid in... What?
Yep, closer to your mouth. Yep.
I'm sorry, I'm a bit distorted. That apartheid got through in South Africa because they appointed one extra judge to change the majority and bring it in. While we have fought to keep the monarchy in the Constitution from the very beginning and preserve the Constitution, is it not that the High Court is the weak link?
It's certainly got the discretion. If I can just comment briefly, it certainly has a discretion which is worrying, and I agree with you, Lloyd, for that very reason. Just to follow up Bruce's question, and noting David's comment about the 2010 elections in which Tony Abbott just missed out, 2 seats of Greenway and Robertson were lost on about 3,000 postal votes, which disappeared. Now, the High Court decided they weren't going to investigate that. But, on the other hand, they allowed 100,000 extra votes in on that decision that brought forward the timing for closing of the polls.
Any further? Yes.
Yes, David. Margaret, I think we're all pretty saddened with what you've been through, and it's absolutely shocking, you and your family. I had a phone call one night, probably about 4 years ago now, at 9:30, and this guy rings me up in broken English and says, "Is that Peter Manuel?" I said, "Yeah." He said, "Well, for what you were up to fighting this water issue, we're going to shoot you." And I said, "Well, that's okay, mate. I've noticed on my phone that your number's come up withheld." So I said, "Would you kindly ring me back with your number so we've got a level playing field?" So I haven't heard from him back since. But I'm just wondering, since ICAC are doing such a fantastic job, is there any way that they can be dissolved?
Being dissolved?
Be dissolved.
Well, I think that should have been the recommendation. It's completely discredited. It's a corrupt organisation. Maybe we need something like that. I would prefer it done within the police force with extra powers, extra coercive powers in a particular, because at least there we get professional investigators. We don't get the likes of the people who came to my place first thing in the morning without no search warrant but a notice to produce. And I said, "This isn't a search warrant. Where are you from?" "I'm from the UK." not that there's anything wrong with that, but as it turned out, these people didn't even know that you don't even incur a toll on your e-tag going north on Harbour Bridge. You know, they're just hopeless. But so I would imagine the government should be able to do something with that, but I don't think they will, because they're all too scared of it. They're all too scared of it. Yes, thanks, Mr. Manuel, and I'm glad to see that that bloke didn't have the.
Yes. Ladies and gentlemen, we've reached the appointed time for the closing of the session. I think, unless you desperately want to continue, it would be appropriate to close. Yes. Yes. We'll have. Yes. The question is, it's about time I wound up the session. So, on the basis of that, I would like to, on your behalf, thank the panel very much for their contributions, which have been so interesting. all of this has been videoed, and it'll go onto YouTube and be available in separate segments, particularly the award of a crown to Mr. Fitzsimons. So it will be interesting, and you'll be able to tell other people that they can see this. And I would like to thank you very much for coming to this 17th National Conference and for being such good and loyal supporters of the constitutional monarchy. Until next year, thank you very much.